Title IX uses the word sex. So does the Fair Housing Act, which basically says that it's unlawful, and I'm paraphrasing, to engage in discrimination on the basis of sex, among other factors, right, in the rental or sale of living space, right? So you have this word, sex, being used in these statutes, and if the court is going to interpret sex to include sexual orientation and gender identity, then one would assume, under textual analysis, that we're going to open up more opportunities, right, in these other statutory realms. The same thing applies in the constitutional domain. So when you look at some of the key gay rights cases of the last decade, right, those cases treated sexual orientation as different from sex, right? And the court didn't apply intermediate scrutiny. It applied some sort of rational basis scrutiny, or rational basis with a bite. But it never said that sexual orientation was sex discrimination. If in fact you cannot engage in discrimination on the basis of gender identity or sexual orientation without necessarily discriminating on the basis of sex, then that means in the constitutional realm, right, the LGBTQ community in their claims ought to be subject to heightened scrutiny, intermediate scrutiny, and maybe more.
I am hopeful on the constitutional side that it might also be inspiring for folks who are bringing litigation in our state courts here in North Carolina. Among other things, there's an appeal right now around the domestic violence protective order statute that I won't go into at length, but there were arguments made under the state constitution that the prohibition on discrimination on the basis of sex means that the general statutes cannot discriminate on the basis of sexual orientation. And Attorney General Josh Stein submitted an amicus brief to that effect. And it was incredibly heartening to see the highest law enforcement officer in our state give his interpretation of sex discrimination as including sexual orientation. So I do think there's a lot of possibilities.
Justice Alito actually gave us pages and pages of statutes that prohibit discrimination on the basis of sex. And so we kind of have we have an outline to bolster the argument that the court had not considered the far-reaching consequences of its actions. But in fact, it's a roadmap that we can kind of go through and check the box. So
thank you, Justice Alito. At the very end of Gorsuch's majority opinion, he basically says that how this decision relates to other statutes is a question for future cases, and it wasn't raised before the court. So I think that the court left some leeway. I don't know how they're going to circumvent this decision for future interpretations of other federal statutes that use the word sex. He also did not address the question of bathrooms and locker rooms and dress codes under Title VII, right? So Title VII prohibits discrimination on the basis of sexual orientation and gender identity, then you should not be able to prohibit someone from using the restroom that aligns with their gender identity. But the court said we're not getting into how Title VII even applies with regards to those concerns. So I think that there's a lot of terrain that we have to cover, even with regards to the application of this opinion in Title VII.